In a Manhattan courtroom, my parents stood before a judge and testified under oath that I was mentally incompetent. They demanded immediate control over my bank accounts, my apartment, and the $2 million trust my grandfather left me. Their lawyer smirked, practically counting his contingency fee. But his smile vanished when the judge read the true list of my assets out loud. I did not just have $2 million. I had $450 million, and my private equity firm had just purchased the debt of the very law firm trying to lock me away. The lawyer went pale and stood up abruptly. The judge slammed his gavel and shouted for security. My name is Josephine Caldwell, and I am 33 years old. I work as a private equity liquidator and venture capitalist. In simple terms, I buy failing companies, strip them down to their bare bones, and sell the profitable pieces to the highest bidder. It requires a cold heart and a clinical mind. I have both. For my entire life, my family viewed me as an ATM to fund their delusions of grandeur. They assumed my wealth was just a lucky streak that they were entitled to manage. Today, I was finally liquidating my most toxic asset, my own family. The courtroom was quiet, except for Harrison Cole shuffling his papers. He was a partner at a mid-tier corporate law firm, and the man my parents had hired to orchestrate a legal takeover of my life. Cole adjusted his silk tie and addressed the judge as if the result had already been purchased. He described my 80-hour workweek's unmarried life and aggressive investment decisions as symptoms of mental instability. Then he lifted a stack of evaluations from a clinician my parents had selected and asked the court to appoint them temporary guardians over my property. I sat at the respondent's table with my hands resting on a single black leather folder. I had counsel available, but I chose to answer the narrow, factual questions myself while my attorney remained in the gallery, ready to intervene. My father Richard dabbed his eyes with a handkerchief, wearing a bespoke suit I had paid for 3 years earlier. Patricia sat beside him, clutching a Chanel bag that cost more than my first car. They nodded solemnly, while Cole claimed they only wanted enough authority to protect me from myself. Their petition focused on the $2 million trust my grandfather had created for me. It had matured the previous week, and my parents believed it could rescue Preston's newest failing business. They assumed I was a moderately successful consultant with a nice apartment and a dangerous appetite for risk. They thought a paid medical opinion and a frightened family narrative would be enough to obtain an emergency property guardian before I could object. But an Article 81 proceeding was not a private asset grab. The court had appointed an independent evaluator, and that evaluator had interviewed me, reviewed my daily functioning, and found no unmet personal or property management need. My folder contained that report: a current assessment from an independent physician, certified tax returns, audited balance sheets, and the bank records, proving I personally managed a complex portfolio without missed obligations or unexplained losses. The judge looked over his glasses. Ms. Caldwell, your parents allege that you cannot understand the consequences of your financial decisions. Do you wish to address the petitionary? I stood and smoothed the front of my blazer. Yes, Your Honor. I am not asking the court to treat wealth as proof of capacity. I am asking the court to compare their accusations with the independent evaluator's findings and my medical records, and the actual performance of the assets they claim I am squandering. I handed the black folder to the bailiff. Cole scoffed under his breath, but the sound died when the judge opened the first exhibit. The independent evaluator found me fully oriented, capable of explaining every major holding, and able to identify less restrictive alternatives to guardianship. The medical report found no cognitive impairment. The next pages were verified federal tax filings and audited statements. Counselor, the judge said, his voice suddenly tight, did you review these materials before asking for emergency control of the respondent's property? Cole stood with the same confident smile. We estimate her net worth at approximately $3 million, Your Honor. The trust, the apartment, and several speculative accounts. The judge placed the papers on the bench. Your estimate is wrong by roughly $447 million. Ms. Caldwell is the sole owner of Apex Capital Partners. She holds controlling interests in 3 multinational companies and a board seat at a commercial bank. More importantly, the independent evaluator found no functional limitation supporting the powers requested. My mother gasped. Richard gripped the edge of the table. Cole's smile vanished. There is another disclosure, I said. 2 weeks ago, your firm defaulted on the mortgage and secured credit facility tied to its Hudson Yards headquarters. The lender sold those defaulted notes through a competitive process. Apex purchased them. I did not claim I suddenly owned his building. I did not need to. My company now held the debt, the assignments, and the right to pursue the remedies written into the loan documents after the required notices and cure periods. Cole had walked into court seeking control over the property of the creditor, currently reviewing his firm's default. His face went pale. He rose so quickly his chair struck the floor. Stop! I need a recess. I cannot continue until my firm reviews this conflict. You may request permission to withdraw, the judge said sharply. You may not abandon your clients in the middle of a hearing. Sit down. Richard exploded before Cole could answer. He lunged around the table, shouting that I had hidden a fortune while the family was drowning. Court officers intercepted him at the rail and forced him back as the judge called for security and warned him that one more step would result in contempt. During the struggle, Patricia surged to her feet and screamed over the officers. Your money is useless anyway! I used the power of attorney from your hospitalization and moved the entire $2 million into Preston's company this morning. It belongs to your brother now. The room went silent. The judge ordered the court reporter to mark the statement and directed the clerk to preserve the hearing record. Patricia had not proved every element of a crime by shouting, but she had admitted an unauthorized transfer while asking the same court to trust her with my property. My bank records already showed that the old authority had been revoked, that a scanned version had been altered, and that the trust distribution instructions carried a forged signature. Her outburst had just connected her to the transaction in her own words. I did not flinch. I did not raise my voice. I simply checked the time on my Cartier watch. It was exactly 10:30 a.m. The financial markets had been open for an hour. I know, Mother, I said, my voice slicing through the heavy silence of the courtroom. And guess who is behind the venture capital fund that acquired Preston's startup this morning? My mother's proud expression fractured. She blinked rapidly, her mind failing to process what I had just said. What are you talking about? She stammered. Preston just secured anonymous angel funding. He told us his app is going public. He is a CEO. I let out a soft, humorless laugh. Preston has never written a viable business plan in his entire life. You and Dad forced me to work 2 jobs in college just to pay for his rent while he failed out of 3 different degree programs. You remortgaged your own house to fund his fake tech startup. He built a useless app with stolen source code, and he burned through all your money playing high-stakes poker in Atlantic City. He was desperate for liquidity to cover up the fact that he was embezzling investor funds. My father stopped struggling against the bailiffs, his eyes widening in horror. You are lying, my father gasped. Preston is on the verge of a massive breakthrough. Preston was not on the verge of a breakthrough, I said. He was facing default investor demands and a source code claim. Weeks ago, an anonymous fund offered a rescue investment that gave the fund preferred shares inspection rights and step-in protections if he misrepresented his liquidity. He signed every page because he needed cash. I looked directly at Patricia. The power of attorney from my appendix surgery was revoked years ago. I did not leave it active to tempt you. I left the account under enhanced monitoring because copies of the old document had disappeared from my files. This morning, someone submitted an altered version with my forged trust instructions. The bank allowed the transfer to post only after preserving the authentication trail and notifying my counsel. Patricia's handbag slipped from her fingers. "You tricked us!" "No. I protected myself and documented what you chose to do. Preston accepted money he knew came from my trust, certified it as legitimate operating capital, and used that certification to satisfy the rescue agreement. The transfer did not magically hand me his company. The preferred shares and audit rights already existed. His false certification triggered the contractual protections." I turned to the judge. "Your Honor, the independent evaluator found me capable. The medical evidence supports that conclusion, and the petitioners have now admitted conduct directly inconsistent with any claim that they should manage my property. I ask that the petition be dismissed, that the disputed medical submissions be preserved, and that the transfer records be referred to the appropriate authorities." The judge did not sit speechless. He denied the request for emergency guardianship, scheduled a short return date to address sanctions and the questionable medical exhibits, and ordered that neither petitioner contact my banks or trust administrator. Cole was told he could file a formal motion to withdraw after substitute counsel appeared. Only then did I collect my folder and walk toward the doors. I picked up my black folder and walked down the center aisle. My parents stared at me as if they were looking at a stranger. They had spent my entire life treating me like an obedient workhorse, a stepping stone for their perfect son. They thought my quiet nature was weakness. They thought my refusal to engage in their petty family drama meant I was a target. They never realized I was just quietly building an empire while they were building a house of cards. "Josephine, wait," my father called out, his voice suddenly weak, stripped of all its previous arrogance. "Please, we are your family. You cannot do this to your brother. He will go to prison." I paused at the heavy oak doors of the courtroom. I looked over my shoulder, my gaze sweeping over the two people who had spent decades tearing me down. "Preston is an adult," I said softly. "It is time he learned how to manage his own liabilities. And since you two seem so eager to handle my legal affairs, I suggest you find a very good defense attorney for yourselves. Though I highly doubt Mr. Cole will be taking your calls." Outside the courtroom, 5 people waited near the elevators my forensic team. Outside counsel and 2 SEC enforcement attorneys who had already opened an inquiry after receiving complaints from Preston's investors. They were not employees I could command, and they were not there to perform a dramatic raid on my order. They were there to serve document requests and coordinate preservation of records that might otherwise disappear. My lead auditor held out a tablet. The $2 million posted at 9:01. Preston's certification followed 4 minutes later. That activated the inspection and protective control provisions in the rescue agreement. We can mirror the ledgers and preserve the servers without interrupting payroll or customer operations. I nodded. Send the authentication logs, the altered power of attorney, and the source code analysis to counsel. Let the SEC decide what belongs in its investigation. Our team will issue the contractual litigation hold and create read-only forensic images. No deletions, no shutdown of legitimate services, and no one touches evidence without a chain of custody record. "Do we warn Preston before the preservation team arrives?" the auditor asked. I stepped into the elevator. "Serve the notice exactly as the contract requires. Do not give him extra time to rewrite the books. Preserve every server. The hunt begins." The line between private control and government authority mattered. I could protect my investment, but only courts and regulators could compel outsiders or impose public sanctions. We pulled up to a towering glass skyscraper in the heart of Manhattan. The penthouse level had been rented out for a lavish Series B fundraising gala. This was Preston's grand illusion. He was throwing a $1 million party using stolen money to attract even more money from unsuspecting venture capitalists. I stepped from the vehicle with 3 senior auditors and outside counsel. 2 SEC attorneys entered separately to serve subpoenas, already authorized in their investigation, They were not my personal enforcement squad. Building management admitted us. After reviewing the acquisition agreement, the court filed preservation notice, and the contractual inspection rights Preston had granted the anonymous rescue fund. Every credential was checked before the elevator moved, and every person entered under a documented legal role. The elevator doors chimed open to the sound of heavy bass, clinking champagne flutes, and the obnoxious hum of wealthy people congratulating themselves. The penthouse was draped in modern extravagance. Waiters carried silver trays loaded with beluga caviar and vintage champagne. Giant LED screens wrapped around the room, displaying sleek hockey stick growth charts and buzzwords like algorithmic synergy and disruptive technology. It was a perfectly crafted theater of success, designed by a man who had never actually worked a day in his life. Preston stood on a raised stage at the center of the room, holding a microphone. He was wearing a custom velvet tuxedo, playing the role of the visionary tech founder. Surrounding the stage were dozens of high-net-worth individuals, hedge fund managers, and angel investors who had already bought into his lies. And that is why our proprietary code will revolutionize the data sector, Preston boasted to the captivated audience. We are not just building an app. We are building a legacy. With this new round of funding, we are fully solvent, backed by immense private equity, and ready to change the world. I walked straight down the center aisle. The crowd naturally parted as my team and the federal agents moved with purposeful, aggressive synchronization. It took Preston exactly 5 seconds to notice the shift in the room. His bright, arrogant smile faltered when his eyes locked onto my white suit. He gripped the microphone tightly, his knuckles turning white. He recovered quickly, falling back on the narrative our parents had spent years crafting. He plastered a look of deep, sympathetic concern on his face and spoke directly into the microphone. "Ladies and gentlemen, I apologize for the interruption," Preston said, his voice dripping with fake pity. "Security, please escort my sister out of the building. She is severely unwell. We actually just came from a court hearing regarding her mental health. Please try to be gentle with her. She suffers from extreme delusions and should not be wandering the city alone." A murmur of sympathy rippled through the crowd of investors. A few security guards, positioned near the stage, started to move toward me. They thought I was a tragic liability, a crazy relative, ruining a genius tech founder's big night. I did not stop walking. I did not raise my voice or show a single ounce of emotion. I simply snapped my fingers and pointed at the audiovisual booth in the back of the room. My lead auditor had already positioned himself there. "Cut his mic," I commanded. Instantly, the sound system died. Preston tapped the microphone uselessly, a sharp screech of feedback ringing out before the room plunged into an awkward silence. The security guards hesitated, unsure of why the production team was obeying my commands. I stopped 10 feet from the stage and looked up at my brother. "As of this morning, Apex holds the controlling preferred position in your company. The rescue documents you signed gave us inspection rights and emergency protective authority if you lied about solvency, ownership of the code, or the source of your capital." Preston laughed too loudly. "She is delusional. My mother secured legitimate financing this morning." "Your mother transferred money from my trust using an altered power of attorney and a forged instruction. You then certified those stolen funds as unrestricted company capital. That certification triggered the step-in provisions you signed." His confidence collapsed. The investors in the front row turned toward the attorneys and auditors behind me. "Put the verified ledgers on the screens," I said. The display changed. The glossy growth charts disappeared and were replaced by bank records, expense reports, source code comparisons, and a timeline showing every transaction. My team had not hacked the company. The data came from the audit mirror created under the rescue agreement and from records produced to the SEC under subpoena. The originals remained preserved, hashed and untouched. Preston had believed the word anonymous meant harmless. In reality, the fund's identity had never mattered to the enforceability of the covenants. His board approved the rescue, his counsel issued an opinion, and he personally warranted that the books were accurate. The screen now showed exactly how many warranties he had broken. The investors were not watching a family argument anymore. They were watching a control covenant activate in real time. I turned to face the crowd of elite investors. "My brother has been pitching you a revolutionary data algorithm," I said, projecting my voice to reach the back of the room. "I hate to break it to you, but the source code for his app was copied from an open-source forum 3 years ago. It has zero market value. The money you have been pouring into his Series A funding was not used for research or development. Let us look at the actual company expenses, shall we?" I pointed to the massive screen on the left. Last month, the company payroll account wired $400,000 to an offshore gambling syndicate in Macau. I pointed to the screen on the right. 3 weeks ago, your investment capital was used to purchase a customized McLaren sports car registered under a shell company. 2 days ago, he authorized a $500,000 corporate loan to pay off a private bookie in Atlantic City. He was technically bankrupt 4 days ago, I continued, cutting through the rising noise. He needed a massive influx of cash today just to prevent federal regulators from flagging his empty accounts. So our parents stole my trust fund to balance his books long enough to steal your money tonight. You are not investing in a tech company. You are funding the lifestyle of a degenerate gambler. A tall, silver-haired man in the front row, who I recognized as a prominent hedge fund manager, stepped forward. His face was purple with rage. He pulled out his phone and stared at the screen, then looked up at Preston. "I wired you $3 million yesterday, you little parasite," he yelled. "My compliance team just ran a check on your holding accounts. The money is gone. Where is my money?" Another investor, a woman in a sharp navy dress, marched right up to the edge of the stage. "You told me the software patent was pending," she screamed. "You used my capital to buy a sports car. I will see you in federal prison." Preston backed into the LED wall, while investors surged toward the stage demanding explanations. Hotel security formed a barrier to prevent violence, and the SEC attorneys served Preston with a preservation subpoena in full view of the room. No one arrested him that night. The more important cage was already closed. His accounts were under review. His records were preserved, and every investor now knew exactly where the money had gone. Preston raised his hands, attempting to placate the furious billionaires closing in on him. "Please, everyone, just listen to me," he begged, his voice cracking. "This is a temporary liquidity issue. I can explain the expenses. The algorithm is still going to disrupt the market. We just need to pivot our deployment strategy. I swear, you will all get a 10 times return on your investment if you just give me 30 days. The crowd did not quiet down. If anything, his pathetic attempt at corporate speak only fueled their rage. I stepped up onto the stage, standing right beside him. The pristine white of my suit contrasted sharply with his sweat-soaked velvet tuxedo. I gestured to my lead auditor, who immediately updated the projection screens. "There will be no pivot, Preston," I said, my tone analytical and completely devoid of pity. "I told you all that his source code was copied from an open-source forum, but I left out the most important detail. The original developers discovered the theft last week. 2 days ago, they filed a massive copyright infringement lawsuit in federal court. You do not own a revolutionary app. You own a stolen prototype with a multi-million-dollar legal target painted on its back." A collective gasp swept through the room. The reality of the situation fully crashed down on the investors. They had not just lost their money to a gambling addict. They were now tied to a toxic company facing devastating intellectual property litigation. "You set me up!" Preston shrieked, pointing a trembling finger at me. "You planned this to ruin life!" "I did not make you steal code. I replied evenly. I did not make you wire investor capital to Macau or buy a luxury sports car. You ruined your own life. I just turned on the lights so everyone else could see the wreckage. The silver-haired hedge fund manager pushed his way to the front of the stage. His face was a mask of pure corporate ruthlessness. You listen to me, you pathetic little con artist, he snarled at Preston. I do not care about your sister or your stolen code. I care about my $3 million. I am going to sue you into oblivion. I will freeze every asset you have ever touched. I will take the clothes off your back. I have nothing, Preston cried, falling to his knees. The velvet trousers of his tuxedo hit the floor with a heavy thud. She took everything. My accounts are frozen. The company is gone. You cannot sue me because I am entirely broke. The hedge fund manager let out a dark, terrifying laugh. Do you think I am an amateur? I run a multi-billion-dollar fund. I do not hand over capital without ironclad assurances. Did you really think I trusted a 20-something dropout with my money without a backup plan? Preston looked up, tears streaming down his face, completely confused. What are you talking about? When Preston signed the Series A documents, the company lacked the history required for unsecured institutional capital, the investor said. The fund required a personal guarantee and collateral package. Preston stared at him. I signed the papers myself. You signed for the company. Patricia signed the guarantee. She pledged her interest in the family estate as collateral. The investor did not claim he could seize the mansion that night. A default would allow the lenders to accelerate the debt, file the required foreclosure action, and pursue the collateral through the procedures written into the loan documents. The result could still cost my parents their home. It simply would not happen by a billionaire snapping his fingers. If the company defaults or the intellectual property claim destroys its value, he said, we will enforce every remedy in the agreement. Patricia's signature therefore created exposure, not instant transfer of title. Notice default judgment and sale would still have to occur in the proper order. Preston stared at him, his mouth opening and closing without any sound. He was finally grasping the magnitude of his actions. He had not just destroyed his own future. He had legally signed away the roof over our parents' heads. I looked at the screens displaying the debt and the pending copyright case. My parents had been so desperate to prove their golden boy was a genius that they pledged the estate's equity behind his company. They had not handed over the deed that night, but their guarantee exposed the house to acceleration foreclosure and eventual sale if Preston's enterprise defaulted and a court entered judgment. Preston looked at me as the SEC attorneys finished serving the subpoena. Josephine, they are going to take the house. You have to help them. I adjusted the cuffs of my white blazer. You should have thought about that before you pledged their home to support a company built on stolen code. I left him, surrounded by furious investors' counsel and hotel security. My phone buzzed before I reached the elevator. Patricia had arrived at the lobby of Apex Capital Partners, demanding to see me. I told reception to schedule her for the first available appointment the next morning. Panic did not entitle her to storm a secured office. The agents also warned him that destroying or altering the subpoenaed material could create a separate obstruction problem. The next morning, I entered Apex Capital Partners with an updated preservation report on my desk. Preston had not been arrested at the gala. The SEC had served subpoenas, investors had filed complaints, and our contractual audit team had secured read-only images of the company records. Criminal authorities would decide whether charges were justified. The trap did not require an early arrest. Send her in, I said, taking my seat behind my massive obsidian desk. Seconds later, the glass doors opened, and Patricia stormed into my office. Her makeup was smudged, her silk blouse wrinkled, and the elegant facade she had maintained in court had collapsed. She had spent the night calling banks, lawyers, and Preston, then waiting for the appointment my receptionist gave her. Panic made her look exhausted, but it did not give her permission to command my workplace during a regulated workday. She did not wait for an invitation to speak. She immediately collapsed into one of the Italian leather guest chairs opposite my desk and buried her face in her hands. She began to sob loudly, her shoulders heaving with exaggerated sorrow. "Josephine, please!" she wailed. "You have to stop this! Call off the auditors and end the investigation!" Preston spent the entire night with lawyers while the SEC preserved his records and investors demanded answers, and every major client began calling him a liar. He is terrified. We are your family. How can you sit there and do this to your own flesh and blood? I did not offer her a tissue. I did not soften my posture or show a single ounce of empathy. I simply took a slow sip of my espresso and pulled a fresh financial dossier toward me. "Preston committed corporate fraud," I replied, my tone clinical and detached. "He embezzled investor capital to feed a severe gambling addiction, and you enabled him by committing wire fraud to steal my trust fund. I do not control the Department of Justice, Mother. Your golden boy broke federal laws, and now he is facing federal consequences." Patricia lifted her eyes wide and pleading. She leaned over my desk, grasping her hands together in a desperate prayer. "But you control the debt, Josephine. You are the majority shareholder of his company now. If you drop the internal audit and just pay off that horrible hedge fund manager, we can fix this quietly. We can make the lawsuit disappear. I am your mother. I carried you. I raised you. You owe me this. You cannot let them take our home." I set my espresso cup down with a sharp clink against the glass coaster. "You only remember that you are my mother when the bill comes due," I said, leaning forward slightly. "Yesterday, you were a conspirator, eager to lock me in a psychiatric ward so you could drain my bank accounts. You personally guaranteed a highly toxic investment for Preston, and you wagered the family estate to do it. That was your signature on the collateral agreement, not mine. I owe you absolutely nothing." Patricia stared at me for a long moment. She searched my face for any sign of weakness, any lingering childhood trauma she could exploit. When she found only cold indifference, the tears instantly vanished. It was like flipping a switch. Her sorrow evaporated entirely, replaced by the vicious, malicious entitlement I had known my entire life. "Fine," she spat her voice, dropping to a harsh hiss. "If you will not do the right thing for your own family, I will force your hand. I am not going to let a greedy little sociopath ruin my life and take my house. I will destroy you." I raised an eyebrow, inviting her to try. "How exactly do you plan to do that?" Patricia stood up, slamming her hands flat against my desk. Her eyes burned with toxic confidence. "Last night, while I was waiting in your lobby, I wired a massive retaining fee to Zenith Crisis Management. They are the most aggressive and ruthless public relations firm on the East Coast. If you do not authorize a full corporate bailout for Preston by noon today, I am authorizing them to go nuclear." She leaned closer, a cruel smile spreading across her lips. "I will go on every major morning television network. I will sit under the studio lights and cry for the cameras. I will tell the entire world that you are a corporate vulture who preyed on her own struggling family. I will say you orchestrated a hostile takeover to steal your brother's company and purposely threw your elderly parents out on the street out of pure spite. Your institutional investors will flee. Your board of directors will demand your resignation. I will drag your reputation through the mud until you are left with nothing but ashes." I let out a soft, humorless sigh. I reached across my desk and picked up a slim, silver remote control. I aimed it at the glass wall to my right and pressed a single button. The smart glass instantly turned opaque, transforming into a massive, high-definition presentation screen. "Zenith Crisis Management," I repeated. "Aggressive, expensive, and careless with its own finances." I turned the glass wall into a corporate chart. Apex had acquired a controlling interest in Zenith a month earlier through a disclosed restructuring. Patricia's proposed campaign had been flagged by the firm's ethics council because it targeted the controlling shareholder and relied on claims contradicted by court records. Her face tightened when her intake form appeared on the screen, marked "Declined." "The retainer is not mine to steal," I said. "It remains in Zenith's client trust account and will be returned after the firm deducts only the documented intake costs allowed by your agreement. What you purchased was not a weapon. You purchased a written record showing that you planned a national smear campaign based on statements you knew were false." Patricia began to shake. Even her final public relations threat had produced evidence instead of leverage. The firm had also preserved her proposed talking points timestamps and source materials under a litigation hold because my defamation counsel had already notified Zenith of the dispute. "You think you are so untouchable!" she screamed, her voice echoing sharply off the glass walls of my office. "You think you have all the money and all the power in the world. You think you can just play God with our lives and walk away." I closed the file in front of me. "I am not playing Godmother. I am just playing the game much better than you. Now get out of my office before I have security physically throw you out onto the pavement." Patricia gripped the edge of my desk, her knuckles white. A manic, triumphant shriek tore from her throat. "You are wrong, Josephine. You are dead wrong. We are not out of options. We found someone else." She backed toward the door, eyes bright with triumph. "After the SEC served Preston and the investors froze his funding, your father called someone on Wall Street. He is bigger than you. He hates everything you represent, and he promised to crush your firm before the next court hearing. You started a war you cannot win." She said the financier had reviewed the medical affidavits, the Silicon Valley property records, and Preston's liabilities. That access made him invincible. I watched the heavy glass doors swing shut behind my mother. The echo of her threat lingered in the quiet of my office, but it did not instill fear. It only sparked my analytical curiosity. A Wall Street giant who despised everything I stood for. That narrowed the list down to a select few. I sat back down at my obsidian desk and pressed the intercom to summon my intelligence director. After Patricia left, I asked my legal and due diligence teams to identify the backer she had mentioned. I did not order anyone to break into private accounts, intercept calls, or steal emails. We reviewed public UCC filings, court dockets, the financing documents my parents had submitted in the guardianship case, and communications their own lawyers had produced during emergency discovery. Within 2 hours, the pattern was clear. A shell company connected to Victor Thorne had offered Richard a $10 million rescue package. Draft term sheets referenced Preston's liabilities, the family estate, and a transfer of the Silicon Valley campus held by one of my funds. The package also referred to the same disputed medical evaluations my parents had filed in court. The documents did not give Thorne legal control over me. A medical power of attorney could not transfer corporate assets or erase acquisitions. But he intended to finance a second Article 81 petition, seek a temporary property guardian, and use the resulting litigation to freeze transactions long enough to force a distressed sale. My parents had agreed to support that attack in exchange for money to save Preston. The decisive evidence came from a financing packet Richard himself had signed. It contained a proposed collateral schedule, naming the California property, draft affidavits attacking my capacity, and a side letter promising the Caldwell family $10 million after a court-appointed guardian approved a sale. The documents were reckless, but they were not imaginary. Thorne's counsel had circulated them through a secure data room to potential lenders, and one lender withdrew after my fund disclosed the pending guardianship dispute. I also found Victor's motive in public debt filings. 6 months earlier, my firm had outbid him for the 100-acre Silicon Valley campus. He needed that land to complete a development contract, and the missed acquisition had left his hedge fund supporting expensive real estate commitments with short-term debt. My family was not his partner. They were leverage he planned to discard after they helped create enough legal uncertainty to pressure me. Seeing their signatures beneath the side letter removed the last trace of doubt. They had placed a price on my freedom, my reputation, and my life's work. The amount was $10 million, barely enough to cover Preston's emergency liabilities. They were willing to call me mentally unfit, support a temporary guardian, and push a distressed asset sale so their golden child could escape the consequences of his fraud. They had handed Victor Thorne a loaded gun, assuming he would use it to execute me. But Thorne was arrogant. He assumed that because my parents were foolish, I must be vulnerable too. He thought he could use my family as pawns on a chessboard without realizing I had already flipped the board entirely. My secure phone rang while I was still reviewing the term sheets. "Hello, Victor," I said. Thorne's laugh was low and confident. He admitted funding my parents and claimed their affidavits would keep me trapped in guardianship litigation for years. He boasted that he could pressure lenders, frighten investors, and make the Silicon Valley campus impossible to finance. He did not truly have judges in his pocket. That was theater. What he had was money-aggressive counsel and a plan to weaponize delay. "What do you want?" I asked. "Dinner tonight. 8 o'clock at Le Bernardin. Your parents will be there and Preston will join us." Preston was not joining us from custody, and Victor had not purchased a private release. No criminal complaint had yet been filed. Victor had merely arranged a car, a lawyer, and enough temporary lawful funding to keep Preston at the table, while regulators and investors reviewed the records. "You will sign the Silicon Valley transfer documents," he continued. "You will step back from Apex, and I will withdraw the financing behind your parents' next petition. Refuse, and I will bury every major transaction you have under emergency motions and lender panic." I let the silence stretch. Victor mistook it for hesitation and continued talking, convinced that naming courts, lenders, and deadlines would turn pressure into inevitability. I told him the first petition had already failed. He answered that defeat in one courtroom did not matter. He could finance appeals commission, new experts, and frighten counterparties with allegations even if he never won on the merits. The threat was not legal control. It was commercial paralysis. That distinction told me everything. Victor needed a fast concession because his own balance sheet could not survive a long fight. The Silicon Valley property was not a trophy. It was the missing collateral behind a chain of development obligations and high-yield notes his fund had issued during the previous quarter. I asked why Preston would be present. "Because your family should watch you choose," he said. "They backed me, and I want them to see the moment you understand what that costs." He gave me the private dining room, the arrival time, and the demand that I bring authority to sign. His confidence was so complete that he never asked why I sounded amused. Before hanging up, he reminded me that my parents had already signed sworn statements and that another filing could reach the court before markets opened. I thanked him for confirming the timeline. He mistook the courtesy for fear. The line went dead. I slowly lowered the phone, placing it back on my desk. Victor Thorne thought he had cornered me in an impossible trap. He thought bringing my treacherous parents and my disgraced brother to a Michelin-starred restaurant would break my spirit and force me to submit. He wanted to humiliate me in front of the very people who had sold me out. The private dining room at Le Bernardin offered the kind of secluded luxury that men like Victor Thorne craved when they wanted to feel like emperors. I arrived at exactly 8 o'clock, stepping through the heavy mahogany doors in a midnight blue silk suit. The maitre d' escorted me past the main dining area and pulled back the velvet curtain to the private suite. The scene inside was a masterclass in misplaced arrogance. Victor Thorne sat at the head of the long oak table, swirling a glass of expensive bourbon. He looked every bit the Wall Street predator, with his slicked-back silver hair and custom Italian suit. To his right sat my father Richard and my mother Patricia. They sat up remarkably straight, their faces plastered with smug, vindictive smiles. They truly believed they had finally backed me into a corner. To Thorne's left sat Preston. He wore the same wrinkled velvet tuxedo from the fundraising gala, but the confidence had drained from it. He had not spent the night in federal custody, and Victor had not purchased a special release for dinner. Preston was free because no criminal complaint had yet been filed. What had changed was the world around him. His investors had frozen new funding, the SEC had served subpoenas, and his servers were under a preservation order. "Right on time," Thorne said, pointing to the empty chair. "Sit down. We have documents to finish." I adjusted my blazer and looked at Preston. "The gala did not end well. I hope you finally learned to read the agreements you sign." He flinched. Patricia slammed her hand against the table. "Do not speak to your brother like that!" she hissed. "Victor is arranging the money that will keep the investors from destroying him. You should be thanking the man willing to save this family." Patricia had admitted an unauthorized transfer in court, yet she still treated Preston as the victim. Richard watched Victor, their last financier, with the devotion of a man who knew the offer could vanish. Preston avoided my eyes. Without the microphone applause and glowing screens of his gala, he looked younger and far less important. The subpoenas had not taken his freedom, but they had taken the illusion that he controlled the timetable. Every server he touched was preserved. Every investor he called wanted documents instead of promises. Thorne enjoyed their fear. He wanted the family assembled because their desperation made his demand feel larger than it was. The dinner was not a legal proceeding. It was theater designed to convince me that resistance would cost everyone at the table more than surrender. "I am not the one who needs saving, Mother," I replied coolly. Thorne let out a deep, booming laugh. He reached into his leather briefcase resting beside his chair and pulled out a thick manila envelope. He tossed it casually down the length of the table. It slid to a halt right in front of me. Inside were the Silicon Valley deed my resignation and a consent authorizing an independent property guardian to review Apex transactions. "And if I decline, your parents file a second Article 81 petition with new affidavits and ask for temporary restraints while the court evaluates capacity. My lenders notify your counterparties that control of Apex is disputed. Your board spends months defending transactions instead of closing them." He did not claim a medical power of attorney could transfer my companies. It could not. His strategy depended on litigation delay, temporary orders, lender fear, and a distressed sale. The threat was still dangerous because markets move faster than courts. Richard leaned forward with false disappointment. "Sign the papers. Victor gives us $10 million. Preston's problems disappear, and the family is protected." I looked at the envelope without touching it. They had sold my legal peace not because the documents guaranteed victory, but because they believed enough noise could force me to surrender. The envelope also contained lender notices drafted to create panic the moment the new petition was filed. Victor intended to make every transaction appear unsafe before any judge ruled on the merits. He was selling delay as certainty, and my parents were too desperate to recognize the difference. I looked at the manila envelope. I did not reach for it. I did not even break eye contact with Thorne. Instead, I raised my hand and signaled the waiter, who had been hovering nervously near the doorway. The waiter hurried over, holding a leather-bound menu. "Good evening, madam," he said politely. "May I offer you the tasting menu, or would you prefer to order à la carte?" "I will take the Imperial Beluga Caviar," I said, my voice carrying clearly across the silent room. "The full serving, please, and bring a bottle of your vintage Dom Perignon. Actually, make it two." The waiter nodded quickly and rushed out of the room. Thorne frowned, his smug expression faltering for a fraction of a second. "What are you doing? I did not invite you here to dine. I invited you here to surrender." I leaned back in my chair, crossing my legs comfortably. "I am hungry, Victor. Hostile takeovers build up quite an appetite. Besides, if this is my last night as a corporate titan as you claim, I should at least enjoy a decent meal before you lock me in a padded cell." Patricia scoffed, rolling her eyes at my father. "She is stalling. She knows she has no way out, so she is just trying to waste our time. Tell her to sign the papers, Victor." Thorne raised his hand, silencing my mother without even looking at her. "Let her eat," he said, his voice dripping with condescension. "If the condemned woman wants a final meal, I am happy to provide it. It will make the signature that much sweeter." For the next 30 minutes, the atmosphere in the private dining room was suffocatingly tense for everyone except me. The waiters returned with the chilled champagne and the crystal bowl of beluga caviar. I ate slowly and deliberately, savoring every bite. I sipped the vintage champagne, watching the bubbles rise to the surface of the flute. My parents sat in agonizing silence, watching me eat. Preston looked like he was going to be physically sick, trembling in his velvet tuxedo. Thorne glared at me from across the table, drumming his fingers impatiently against the polished wood. He wanted to see fear. He wanted me to beg, or bargain, or cry. My absolute calm was infuriating him. He was a predator who thrived on the panic of his prey, and I was giving him nothing but polite table manners. When I finally finished the last bite of caviar, I gently placed my mother-of-pearl spoon down. I picked up my linen napkin and dabbed the corners of my mouth. I motioned for the waiter one last time. "The check, please," I said. The waiter hurried over with a black leather billfold and placed it on the table. Thorne immediately reached for it, but I was faster. I placed my heavy metal black card on top of the receipt before he could even read the total. "Put it on my card," I told the waiter. Thorne pulled his hand back, a look of deep confusion crossing his features. "I am hosting this dinner, Josephine," he said sharply. "I do not need you to pay the bill." I offered him a sweet, razor-sharp smile. "Consider it a severance package, Victor. It is the least I can do for a man who is about to face sudden unemployment." Thorne froze. His eyes narrowed, assessing my tone. My father leaned forward, looking nervously between the two of us. "What does she mean, severance package?" Richard asked, his voice wavering. I ignored my father and kept my eyes locked entirely on Thorne. I reached out and pushed the manila envelope back across the long table. It slid smoothly, stopping right in front of Thorne's bourbon glass. "I am not signing your transfer deeds, Victor," I said, my voice dropping to a low, dangerous timbre. "I did not come to this dinner to surrender my empire to you. I came to look you in the eye and inform you that as of 20 minutes ago, you lost your seat as chairman of your own board." For 1 second, the private dining room was silent. Then Victor laughed and lifted his bourbon. "You do not have the leverage to remove me," he said. "My directors are loyal, my voting shares are protected, and my fund manages $12 billion. "You manage $12 billion in assets," I corrected. "You do not own $12 billion in free cash." 6 months earlier, after losing the Silicon Valley campus, Thorne's fund had tried to preserve its development commitments by issuing layers of high-yield notes and borrowing against future management fees. The debt was scattered among distressed credit desks' insurance accounts and special-purpose vehicles. Victor assumed no single creditor could assemble enough of it to challenge him. What he did not know was that I had been buying those notes for months, not 48 hours. The previous 2 days were merely the final consolidation. Every purchase had been made through disclosed investment vehicles, reviewed by counsel and reported where required. I did not evade ownership limits or hide behind illegal offshore accounts. I used the same market Victor used every day, sellers who cared more about immediate cash than loyalty to the man who had issued the paper. I had accumulated a blocking position in the secured notes and coordinated with other creditors who were tired of covenant breaches. That morning, an independent collateral agent confirmed another default. Victor had pledged overlapping assets, missed a liquidity test, and concealed the exposure from his own risk committee. Under the indenture, the required percentage of note holders could accelerate the debt and appoint a restructuring representative. The debt did not magically convert into my equity because I said so. It gave the creditor group the right to enforce pledged shares, negotiate a debt for equity restructuring, and remove management that threatened the recovery. I did not buy your company over lunch, I said. I bought the leverage you gave away every time you issued another desperate note. Victor's fingers tightened around the glass. At 7:30, the creditor group delivered a formal acceleration notice. At the same time, the independent directors received the forensic report, showing that Victor had hidden the cross-collateralization and used the Caldwell scheme to obtain the Silicon Valley property for his personal rescue plan. Faced with a default, a potential injunction, and lenders prepared to seek a receiver, the board convened an emergency meeting. They suspended Victor as chairman pending investigation and authorized negotiations with the creditor committee. Patricia stared between us. What does that mean for the $10 million? It means your savior no longer controls the checkbook, I said. Victor slammed his fist on the table. You are bluffing. My board would never vote against me. His secure phone began vibrating. The caller was his chief operating officer. Victor stared at the screen, then answered. He listened without speaking. The color drained from his face as he learned that his access credentials had been suspended. The board had appointed an interim chair, and counsel was preparing a court-supervised restructuring to preserve the fund's assets. His equity had not vanished in a theatrical instant, but his operational power had. If the restructuring proceeded, the secured creditors would control the outcome, and his personal stake would sit behind hundreds of millions in claims. You destroyed my firm, he whispered. No, I said. I documented the default you created and gave your directors a choice between your ego and their fiduciary duties. Victor demanded to know what the creditors had actually filed. I told him the acceleration notice was only the first blade. The collateral agent had frozen discretionary transfers under the loan documents, outside counsel had notified the major counterparties, and the creditor committee was preparing a request for a receiver if management tried to move pledged assets. None of those steps made me owner of his fund that night. Together, they made it impossible for him to pretend the default was private. His general counsel joined the call through the speaker and confirmed that the independent directors had received the same forensic report. They had also received minutes showing Victor concealed overlapping pledges from the risk committee and used the Caldwell guardianship scheme as a proposed source of emergency collateral. The directors were not choosing me over him. They were protecting themselves from claims that they ignored a documented liquidity crisis. I placed a one-page creditor schedule beside my untouched transfer documents. It showed the secured notes, cure notices, pledged management company shares, and voting thresholds. Every number came from instruments Victor had approved. If he cured the default lawfully, the creditors would be paid. If he could not, the restructuring process would determine ownership under court supervision. The only immediate result was that he no longer controlled the timetable or the assets needed to rescue my family. The creditor committee had also filed for emergency relief that afternoon. A restructuring judge had not yet transferred ownership, but the filing prevented Victor from moving pledged assets, issuing new debt, or dismissing the independent directors while the court reviewed the default. His board understood that siding with him could expose each director personally if the fund collapsed after clear warnings. Their vote was not loyalty to me. It was self-preservation, backed by a documented record. By the time he answered the call, everyone at the table understood that the vote, the default notice, and the court filing had converged without depending on a single impossible trick. Preston surged from his chair. "What about the $10 million? What about the investors? You promised the rescue would keep the company alive." Patricia demanded to know whether the estate would still be protected. Richard looked from the unsigned term sheet to Victor's ruined expression and realized that every promise depended on a man who no longer controlled his own fund. Victor turned on them with open contempt. He lifted the bailout packet from the table. The document was an unsigned term sheet conditioned on my surrender lender approval and a board vote that would never happen now. "You told me she was unstable and easy to corner," he said. "You sold me worthless leverage." Richard raised both hands. "We gave you the medical files. We signed the affidavits. We did everything you asked." Victor tore his copy of the term sheet in half and threw the pages across the table. The gesture did not cancel an executed contract because no funded contract existed. "There is no rescue. Your $10 million is gone. Your son's investors will pursue him, and the authorities will decide what happens when they finish reviewing his records." Preston collapsed back into his chair. The terror on his face did not come from being returned to a prison he had never entered. It came from understanding that nothing stood between him and the evidence anymore. My mother grabbed Victor's sleeve and demanded that he call the lenders. He pulled away, as if her touch contaminated him. "You were useful only because you claimed she would panic," he said. "Instead, she bought the leverage behind my own board." Richard tried to revive the bargain by offering additional testimony, more medical records, and complete cooperation in another guardianship filing. Victor laughed. Any new filing would now expose the same documents to discovery, and his own lawyers were already preserving communications for the restructuring investigation. Preston asked whether Victor could at least pay criminal defense counsel or negotiate with the investors. Victor reminded him that no private financier could stop a federal investigation or erase signed certifications. The most he had ever promised was funding, and that promise had depended on control he no longer possessed. They understood they had not purchased protection. They had sold information to a predator who intended to abandon them the moment the transaction failed. "But I still control the vehicle that holds your mortgage debt," Victor said, turning toward my parents. "The loan is in default, the guarantees are signed, and the forbearance period is almost over." He did not own the mansion merely because he held the note, and he could not throw them out by Friday without judicial process. What he could do was continue the pending Connecticut foreclosure, refuse another extension, seek a receiver, and demand every remedy permitted by the mortgage documents. "I will pursue the foreclosure to judgment," he promised. "I will oppose every request for delay, and I will liquidate the collateral through the court before I let you keep a dollar that could pay my creditors." Then he stormed out. The threat remained devastating because it was based on documents my parents had actually signed, not on magic authority. The torn bailout packet on the table was only an unsigned term sheet. Their rescue had never existed. My mother's lips parted as she understood that Victor's promise of immediate homelessness had been exaggerated, but the underlying default was not. Legal process would slow the blade. It would not remove it. The danger came from enforcement, not from his threat alone. "Josephine, wait!" My mother gasped, finally finding her voice. Her chair scraped loudly against the hardwood floor as she scrambled to her feet. "You cannot just leave us here! You heard what he said! He is going to take the house! He is going to leave us on the street! You have to do something!" I did not stop walking. I pushed the heavy doors open and stepped out into the main restaurant. The maitre d' bowed slightly as I passed, completely unaware that the family and the pride had just been financially erased from polite society. I stepped out into the crisp night air of Manhattan. The city lights reflected beautifully off the wet pavement, creating a kaleidoscope of urban energy. My armored town car was waiting at the curb, its engine purring silently. My security chief stepped out immediately and opened the rear door for me. Before I could step inside, the frantic sound of footsteps echoing on the sidewalk made me pause. "Josephine, please stop!" Richard yelled. My father was practically sprinting out of the restaurant, his face red and slick with cold sweat. His expensive tie was askew, and his usual aura of patriarchal authority had completely dissolved into sheer terror. Patricia was right behind him, struggling to run in her designer heels, nearly twisting her ankle on the curb. Preston trailed them, looking like a walking corpse condemned to the gallows. "You have to fix this," my father pleaded, his breathing ragged and uneven. "You own his firm now. You have the power to stop him. You can cancel the foreclosure process. You can pay off the debt. You have $400 million in cash, Josephine. You can save our home. Right now, just write a check. It is pocket change to you." My mother pushed her way forward, tears streaming down her face, ruining her immaculate designer makeup. She reached out and grabbed my forearm, her grip desperate and tight. "We are your family," she sobbed loudly, drawing the attention of well-dressed passers-by leaving the restaurant. "We made a mistake. We trusted the wrong person. We were just trying to protect Preston, but we are still your parents. You cannot let that monster take everything we have worked for. We will do whatever you want. We will sign whatever you need. Just protect us from him, please, Josephine. I am begging you." "You did not make a mistake, Mother," I said, my voice perfectly level and clinically detached. "A mistake is forgetting to file a tax extension. You made a calculated, malicious decision to conspire with a corporate raider. You handed him forged medical documents to lock me in a psychiatric ward so you could drain my accounts. You tried to steal my $450 million empire to fund Preston's gambling addiction and cover up his intellectual property theft. You did not trust the wrong person. You just bet on the wrong horse, and you lost the race." "But he is going to make us homeless," Preston cried, stepping forward, his voice cracking into a high-pitched whine. "He said Friday. He is going to seize the estate by Friday morning. You have to bail us out, Josephine. I am your brother. We share the same blood." I stepped into the back of the town car and sat down on the premium leather seat. I looked at the three of them standing on the sidewalk, shivering in the cold night air. They looked like complete strangers. Pathetic, desperate strangers who had finally met the catastrophic consequences of their own actions. "Victor is ruined," I told them from the open door of the town car. "But he lied about one detail. He no longer controls the vehicle holding your mortgage." Richard's eyes filled with sudden hope. "Then the foreclosure stops." "No." During the restructuring review, the collateral agent identified Victor's personal holding company among the assets pledged to support his emergency credit lines. The mortgage loan on the Caldwell estate sat inside that portfolio. Under the interim court order, the creditor committee gained control of the servicing rights and the pledged equity in the holding company. I did not become owner of the mansion by announcing it on a sidewalk, and I could not evict them with a private demand. Their default, however, was real and old. Months earlier, they had missed payments, received written notices, and signed a forbearance agreement to prevent immediate foreclosure. That agreement expired when Preston's company collapsed, and the guarantee was called. A foreclosure action had already been filed in Connecticut before Victor entered the picture. I pulled a thick white envelope from my bag. It contained the assignment notice, the filed complaint, the expired forbearance agreement, and a proposed consent order. The proposal offered them 72 hours to accept a voluntary surrender date, preserve the property, and avoid additional legal costs. If they refused, the receiver would continue through the court, obtain judgment, schedule the sale, and seek possession under judicial authority. "The paper does not say I can throw you onto the pavement tonight," I said. "It says your final chance to cooperate expires in 3 days." I tossed the envelope toward Richard. It struck his chest and fell to the wet pavement. Patricia screamed that the mansion contained our childhood memories and that no daughter could erase the home where she had been raised. "I was not raised there," I said. "I survived there." Richard asked where they were supposed to go when their remaining wealth was tied to the estate. "That is a liquidity problem created by your signatures," I answered. "Read the documents this time." My father unfolded the first page and saw the case number, the loan history, and the date of the foreclosure conference. The legal timeline denied him the comforting fantasy that I had invented the crisis that evening. Their own missed payments renewals and guarantees had been accumulating long before I acquired the servicing rights. "You can contest the amount request, mediation, or propose a lawful cure," I said. "What you cannot do is order me to erase a default because we share blood." My mother reached for the car door, but my security chief stepped between us without touching her. I had no interest in turning a financial dispute into a physical spectacle. The documents were enough. The heavy car door slammed shut, cutting off my mother's hysterical sobbing and my father's desperate pleas. The driver got into the front seat and started the engine. I rolled the tinted window down exactly 2 inches to observe the final act of the tragedy. I looked out at Preston. He was standing slightly apart from our parents, staring intently at his phone. The screen was glowing in the dark, illuminating his terrified, sweaty face. The device was vibrating violently in his hand, signaling an urgent incoming call. He answered the call, pressing the phone to his ear with a trembling hand. "Hello?" he whispered. I watched his pupils dilate. I watched the remaining blood drain completely from his face, turning his skin an ashen gray. His jaw went slack. The expensive smartphone slipped from his numb fingers and shattered against the concrete sidewalk, sending shards of glass flying. "Preston, what is it?" my mother cried, rushing over to him and shaking his shoulder frantically. "What is wrong? Who was on the phone? Tell me!" Preston did not look at her. He stared blankly at the shattered phone on the ground, his mind completely broken by the information he had just received. "That was my neighbor," he stammered, his voice barely audible over the ambient noise of the city traffic. "The FBI just kicked down my front door. They are seizing all my servers and freezing my personal bank accounts. They have a federal warrant for securities fraud and wire fraud." My father collapsed onto the wet pavement, clutching the eviction notice to his chest, as if it could somehow protect him from the reality of their total destruction. My mother fell to her knees beside him and began to scream, a raw, guttural sound of total, absolute defeat. I pressed the button to roll the window up, sealing myself inside the quiet, luxurious cabin of the vehicle. "Drive," I instructed my chauffeur, looking forward at the road ahead. The car pulled smoothly away from the curb, leaving the complete ruins of the Caldwell family behind in the dark. The next morning I returned to the Caldwell estate with my security chief outside counsel and inventory professionals authorized under the existing forbearance agreement. We were not there to perform an illegal 72-hour lockout. The foreclosure remained before a Connecticut court. Our limited purpose was to preserve collateral document, its condition, and prevent valuable property from disappearing while the receiver sought formal possession. Preston sat on the marble steps. Federal agents had searched his apartment the night before under a warrant copied specified devices and frozen only the accounts identified in the court papers. A magistrate had released him on conditions pending further proceedings. His passport had been surrendered, but no investigator had selected a prison or promised a sentence. When he saw me, he stumbled forward. My security chief moved between us, but I raised a hand and allowed him to approach. Preston dropped to his knees and clutched the hem of my coat. "They have the emails, the source code, and the investor records. My lawyer says the charges could carry years in prison. I will not survive if the judge gives me the maximum." He spoke as though the worst guideline estimate were already a final judgment. No agent decided punishment during a search, and no one yet knew whether he would plead cooperate or force the government to trial. His fear was real. So was the evidence. The warrant had not created his crimes. It had preserved the trail he assumed his family could hide. He looked up at me with the first honest recognition that money and a famous surname could no longer control the timetable. The preservation team remained at the edge of the drive, waiting for counsel to complete the inspection notice. No one entered the mansion, opened a safe, or touched an asset until the contractual authority and court paperwork were confirmed. I looked down at him, feeling the cold morning air against my face. I felt absolutely zero pity. You committed massive intellectual property theft and defrauded institutional investors to fund a severe gambling addiction, I stated, my tone clinical and detached. Federal prison is exactly where men like you belong. He clung tighter to my legs, his tears soaking into my coat. I am begging you, Josephine. I have no money. My accounts are frozen. The public defender they assigned me looks like he just graduated law school. He wants me to plead guilty and accept 15 years. You own a $400 million empire. You can afford the best white-collar defense attorneys in the country. Just hire a legal team for me, please. I will do anything. I will scrub your floors. I will be your servant for the rest of my life. I signaled my security chief. He reached into his tactical vest and produced a sleek black leather portfolio, handing it to me. I opened it and extracted a thick stack of legal documents printed on heavy archival paper. Stand up, Preston, I commanded. He scrambled to his feet, wiping his nose with the back of his trembling hand. He looked at the documents with wide, terrified eyes. I opened the black portfolio and held out the proposed engagement agreement. I have placed funds in escrow for independent criminal defense counsel. The lawyers will represent you, not me. They will not promise a sentence, and I will not tell them what advice to give. Preston stared at the first page. You would pay $5 million for my defense? I will fund competent counsel because any decision to cooperate must be informed and voluntary. The money goes to the firm under a written agreement protecting its professional independence. It is not payment for a particular statement. Behind the engagement agreement was a preservation notice and a chronology of documents already in lawful custody, the altered power of attorney, the trust transfer authentication trail emails, concerning the medical evaluations, payments to Harrison Cole, and records linking the stolen capital to Preston's company. What do you want from me? He asked. The truth. Your lawyer will decide whether to request a proffer meeting with prosecutors. If you choose to cooperate, you will disclose every transaction you participated in and every instruction given by Richard and Patricia. You will not repeat a version I wrote for you. You will answer questions, identify documents, and accept that prosecutors will test every word against independent evidence. He looked toward the mansion. They are still my parents. They tried to have me declared incapacitated so they could reach my property. They altered legal documents, moved my trust money, and used your company to disguise the transfer. Blood does not turn a false statement into the truth. Preston asked whether cooperation would keep him out of prison. No. Your lawyer may seek consideration under the rules that govern substantial assistance, and prosecutors may decide whether your help has value. The judge controls the sentence after reviewing the evidence and the pre-sentence report. Anyone guaranteeing 3 years or a comfortable facility would be lying to you. I handed him the pen, but I did not ask him to sign a confession on the hood of my car. He signed only the attorney engagement, the instruction preserving his devices and records, and consent allowing the firm to contact the U.S. Attorney's Office. His new counsel arrived shortly afterward. The lawyers met with him privately inside one of their vehicles, beyond my hearing and outside my control. They reviewed the search warrant, the potential charges conflicts created by Richard's strategy, and the risks of making a false proffer. More than an hour later, Preston stepped out with his attorney. His face was gray. I am going to cooperate, he said. Then tell them everything, including the parts that make you look guilty. That afternoon, his counsel arranged a recorded proffer at the federal building. Prosecutors and agents advised him that the meeting did not grant blanket immunity. Preston identified Patricia as the person who submitted the altered authority documents and Richard as the person who coordinated the medical evidence and instructed Harrison Cole. He explained his own role in accepting the money and certifying it as legitimate capital. Investigators did not accept his story on faith. They compared it with bank logs, emails, device records, and Cole's files. Where he minimized his gambling or blamed others, they confronted him with documents until he corrected the timeline. When he returned to the estate, he leaned against my vehicle and covered his face. "I told them what happened." "You told them what the records would have proved without you," I said. "Cooperation may affect the outcome. It does not erase what you did." His lawyer confirmed that the retainer was active and that all further communication would go through counsel. For the first time, Preston's future depended on procedure rather than our parents' money. Before leaving, counsel collected Preston's phone, laptop credentials, and a list of cloud accounts so nothing could be deleted, altered, or remotely wiped. The devices remained subject to the warrant, but his voluntary preservation reduced the risk of an obstruction allegation and gave investigators a clean record of what he surrendered. Before I could turn toward the house, sirens rose beyond the gates. Preston flinched and backed against the portico, convinced the agents had returned to revoke his release. 3 unmarked federal vehicles and 2 local police cruisers entered the drive and stopped near the front steps. The agents did not point weapons at the family or storm the property without explanation. The lead agent carried a sealed warrant, an arrest packet, and a separate search protocol identifying the categories of records they were authorized to seize. The affidavit supporting the warrant had been reviewed by prosecutors and signed under oath. It relied on bank authentication records, the altered trust documents Harrison Coles produced, files, and information from Preston's proffer that investigators had independently corroborated. His statement alone was not enough. The search team divided into evidence groups. One team was assigned to electronic devices, another to financial records, and a third to maintain an inventory so personal property outside the warrant would not be swept into the case. Every item taken would be logged, imaged, sealed, and handled through the chain of custody process. Preston raised both hands. "You promised the lawyers would handle this." "They are not here for you," I said. The agents walked past him without slowing. The front doors opened, and Patricia stepped onto the porch carrying a designer travel bag. The lead agent climbed the marble steps and called her full name. No one moved until the warrant was shown. Patricia stared at the federal agent as if he had spoken to her in a foreign language. The designer travel bag slipped from her manicured fingers, hitting the marble porch with a dull thud. For a woman who had spent her entire life meticulously controlling her image, the sight of 2 agents stepping forward with heavy steel handcuffs was completely incomprehensible. "This is a mistake," Patricia stammered, taking a trembling step back toward the heavy oak doors. "I am Patricia Caldwell. You have the wrong person. I demand to speak to your superior." The lead agent did not blink. He grasped her wrist with practiced efficiency and smoothly spun her around. The sharp, metallic click of the handcuffs locking into place echoed loudly across the pristine estate. It was a beautiful, definitive sound. The golden handcuffs she had worn for years, the wealth, the privilege, the social status had finally transformed into actual federal steel. Richard burst through the front doors a second later. His face flushed a dangerous shade of purple. He charged out onto the marble porch, waving his arms wildly. "What do you think you are doing?" he bellowed, his voice cracking with panic. "Take those off her, immediately! My wife is a respected member of this community. You cannot just storm onto my property and arrest her." "We have a federal warrant, sir," the agent replied calmly, securing Patricia's arms behind her back. You can contact her legal representation, but she is coming with us right now. Patricia looked past the agents and found Preston beside my vehicle. She saw the black portfolio in my security chief's hands and understood that he had spoken to counsel. "Tell them you handled the finances," she screamed. "Tell them I knew nothing!" Preston lowered his head. His cooperation had not purchased a guaranteed minimum security sentence, and no one had promised him comfort. It had only given prosecutors information they would test against independent evidence. He could not save Patricia by inventing a new lie, without destroying whatever consideration truthful cooperation might earn. She fought the agent's grip and called him ungrateful, but they moved her down the steps without unnecessary force. Her anger was not proof against Preston, and his silence was not proof against her. The warrant, bank records, and altered documents were the evidence that mattered. Richard shouted from the doorway, but the lead agent warned him not to interfere. The search and arrest continued under supervision, with each step documented rather than performed for the family's humiliation. "Josephine, fix this," Richard demanded, pointing a trembling finger at me. "Call your lawyers. Tell them to meet Patricia at the federal courthouse. Make sure she has independent counsel, and pay whatever lawful bond the judge sets. Do it now." I slowly reached out and pushed his trembling finger away from my face. My tone was so completely devoid of emotion that he actually took a step back. "I am not paying a single cent for her, Richard," I stated clearly. "You have $400 million in liquid cash," he roared, his face twisting in desperate rage. "She is your mother. You cannot let them throw her in a federal holding cell. They will strip search her. They will put her in an orange jumpsuit. She will not survive in there. You have to bail her out." I adjusted the collar of my trench coat, keeping my eyes locked on his. Why would I bail out a woman who forged my signature to drain my accounts? Why would I protect a conspirator who tried to hand over my empire to Victor Thorne for $10 million? You and Patricia paid a corrupt medical professional to draft a fraudulent psychological evaluation. You planned to drag me into a courtroom, have me declared legally incompetent, and lock me inside a psychiatric ward, so you could steal my life's work. I stepped closer to him, invading his physical space, forcing him to look directly into the cold, dead eyes of the daughter he had tried to destroy. "You wanted me in a padded cell, Richard. A federal penitentiary is a massive upgrade for her. Consider it an act of mercy." Richard stared at me, breathing in ragged bursts as the federal SUV carried Patricia toward booking and an initial appearance. His world was collapsing, but none of the outcomes had been decided by spectacle. Preston was a defendant considering cooperation. Patricia faced charged allegations, supported by a warrant, and the estate remained inside a pending foreclosure and receivership process. What Richard had truly lost was the power to dictate every result before a court reviewed the evidence through full judicial process. When he turned back to me, the desperation had vanished, replaced by a toxic, vindictive hatred. The patriarchal mask was gone, revealing the true monster underneath. "You think you have won," he hissed, stepping toward me, his fists clenched at his sides. "You think because you have all this money and all these security guards that you are untouchable. You are a cold, heartless sociopath. You engineered this entire tragedy just to punish us for supporting your brother." "I did not engineer your greed," I corrected smoothly. "I just stopped funding it." "I am going to destroy you," Richard swore, his voice vibrating with absolute malice. "If you will not use your money to save this family, I will make sure you lose every single penny you have. I know people, Josephine. I have connections in the media. I will go on every television network in the country. I will tell the world exactly what kind of monster you are. I will expose how you orchestrated a hostile takeover to steal your brother's company, how you evicted your elderly parents, and how you framed your own mother to settle a petty childhood grudge. Your investors will run. Your board will fire you. I will burn your reputation to the ground. You are welcome to try Richard, I said, turning toward the open car door. But the media only rewards a victim until the records arrive. Right now, you are an insolvent man standing on a driveway already protected by a receiver, threatening the creditor whose documents you signed. I stepped into the luxurious interior of the town car, and the heavy armored door slammed shut, cutting off his screaming. As the vehicle pulled away, I watched through the tinted glass. Richard was standing completely alone on the cobblestone driveway, screaming obscenities into the exhaust fumes, while Preston remained curled in a pathetic ball near the stone pillars. It was a perfect portrait of total liquidation. Section 12. The media war. At exactly 2 o'clock in the afternoon, my private intercom buzzed. It was my director of public relations. Her voice carried a rare note of genuine urgency. "Miss Caldwell," she said crisply, "you need to turn on the national news network immediately. Channel 4. I tapped the silver remote on my desk, transforming the glass wall into a massive high-definition screen, and switched to the designated network. The midday financial and news broadcast filled the room. Sitting in the center of the brightly lit studio, looking directly into the primary camera, was my father. He had somehow managed to secure an exclusive live interview on a major national syndicate. He had traded his expensive custom suit for a slightly worn rumpled sweater, looking exactly like a devastated working-class grandfather. His eyes were red-rimmed, and he clutched a tissue in his hands. The Chiron graphic flashing across the bottom of the screen read in bold letters, "Billionaire daughter destroys family empire." "She took everything," he sobbed, wiping a perfectly timed tear from his cheek. "I worked my entire life to build a legacy for my children, and Josephine, my own flesh and blood, used her massive wealth to illegally seize our family business. She threw her mother in federal prison this morning on fabricated charges. She sent an eviction squad to throw me out of my home of 30 years. I am begging the authorities to investigate her corrupt practices. She is a corporate predator, and she is destroying innocent lives." The broadcast cut to a panel of financial commentators and morning show anchors whose expressions mirrored absolute outrage. Within an hour, the narrative was set. I was the ruthless corporate vulture, the ungrateful daughter who had weaponized her massive wealth to destroy her wholesome middle American family. My intelligence director sent real-time social media analytics to my tablet. The backlash was instantaneous and completely feral. The internet demanded regulatory investigations into my hostile takeover of Victor Thorne's firm. My PR director paced the length of my office, her heels clicking anxiously against the hardwood floor. She held a thick binder of proposed crisis management strategies. "We need to get you on primetime television by tonight," she urged, her voice tight with panic. "We need you, wearing a soft pastel sweater, looking vulnerable. You need to shed a tear, talk about the painful complexities of family business, and beg the public for understanding. If we do not humanize you immediately, the board of directors will call an emergency vote of no confidence." "I am not wearing a pastel sweater," I replied, my tone entirely devoid of panic. "And I certainly do not beg for understanding. Apologies are for people who have committed a miscalculation. I executed a precise financial strategy, but the public perception is plummeting," my PR director insisted, gesturing to the red arrows on my tablet screen. "They think you are a monster." I opened my desk drawer and removed a silver flash drive. The file on it had already been copied to a secure evidence repository, and an independent examiner had prepared a declaration confirming its source and integrity. "Send the declaration and relevant excerpt to counsel for the network," I instructed. "Offer the same package to every outlet that requests it. Do not bypass editorial review, and do not publish private account numbers or confidential medical details." My director looked at the drive. "What is it?" A voicemail Richard left when he thought the call had ended. Within 30 minutes, the first network interrupted its programming. Others followed after verifying the provider records. The story was no longer my denial. It was a documented conversation between the people who had asked a court to control my life. Outside counsel reviewed the release language before any newsroom received it. The network introduced the excerpt with a clear disclaimer the audio had been independently authenticated, the source records were preserved, and the allegations remained subject to judicial review. The recording had not come from a hidden device planted inside my parents' home. Richard had called my private number 2 weeks earlier to threaten me. He believed he had ended the call, but the connection remained open and continued recording to my voicemail system while he and Patricia discussed the plan in the same room. Their voices were unmistakable. "We need the evaluator to sign the paranoia diagnosis," Richard said. "Use the shell account for the payment. Once the court appoints a property guardian, we can reach the trust and pressure her board." Patricia asked whether they could move the money quickly enough to buy Preston the yacht he wanted for the launch party. "The moment the guardian has authority, we transfer what the court allows and use the freeze to force Josephine into settlement," Richard answered. The file ended with glasses clinking. Before release, an independent examiner had compared the voices with known recordings, verified the voicemail metadata, and preserved a hash of the original file. My lawyers provided the same material to prosecutors. The public broadcast did not create a criminal case from nothing. It added a direct admission to bank records, forged documents, and sworn statements already under investigation. The reversal was immediate. Networks that had portrayed Richard as a victim began asking why he had concealed the guardianship scheme. Later that day, prosecutors presented the corroborated evidence to a magistrate who approved a warrant. Police arrested Richard outside the studio after advising him of the charges and his rights. The cameras captured the result of his own broadcast, not an arrest ordered by me. The network's lawyers reviewed the report before airing the recording. They did not publish private account numbers or confidential medical information. They broadcast only the portions necessary to show Richard's plan and Patricia's participation. My team simultaneously released the independent examiner's declaration explaining the source chain of custody and absence of editing. Richard tried to claim the voices were synthetic. That defense collapsed when the voicemail provider produced the original server record and when the timing matched calls, payments, and drafts already in the government's possession. The evidence did not depend on public outrage. The outrage merely prevented him from hiding behind a carefully staged television performance. The provider also confirmed that no employee of Apex had altered or enhanced the file before the forensic copy was created. 3 days later, I entered the federal courthouse for the joint fraud trial of Richard and Preston. Patricia's case had been severed because her counsel was negotiating separately. Preston had given a cooperation proffer, but the government had not granted immunity or promised a sentence. He remained a defendant represented by independent counsel, and every statement he made could be tested against the records. I sat in the reserved victim seating behind the prosecution. Richard occupied one defense table with his own lawyers. Preston sat at another. The physical distance between them reflected a conflict the judge had addressed before the jury entered. Father and son could no longer pretend one strategy protected them both. The prosecutor called Harrison Cole as the government's next witness. Cole walked down the aisle without the confidence he had displayed during the guardianship hearing. His law firm was under creditor pressure. His professional conduct was being investigated, and the files he once believed would protect the Caldwell family had become exhibits bearing his signature. Before Cole took the oath, the judge explained the limits of his cooperation agreement. It required truthful testimony and production of records. It did not erase civil liability, bar discipline, or punishment for any new lie. The jury was told to evaluate his testimony with caution and to compare it with emails, billing records, bank transfers, and document metadata. Cole raised his right hand. Preston stared at him with open fear. Richard's attorney arranged his papers as if organization could still control the story. The prosecutor approached the witness stand with the first authenticated email already displayed on the courtroom monitor. That was the moment the family's common defense finally ended. Cole was not there to offer a moral confession. He was there because the documentary trail made silence more dangerous than cooperation, and because every person in the scheme had begun calculating how much of the truth he could trade for himself. Harrison Cole settled into the witness chair and swore to tell the truth. His cooperation agreement was limited. It required complete disclosure and allowed prosecutors to consider his assistance, but it did not erase possible civil liability, disciplinary action, or punishment for any false statement. The prosecutor established that Cole had represented Richard and Preston, prepared transaction documents, and communicated with the clinician used in the guardianship scheme. Then the government introduced his emails, billing entries, bank records, and document metadata. Cole explained how false vendor invoices moved investor money through shell companies, how Richard approved transfers used to cover Preston's gambling losses, and how the altered trust documents were routed for signature. He identified the messages in which Richard demanded a medical opinion strong enough to support emergency control of my property. Every important claim was tied to an exhibit. Cole was not being trusted because he had become honorable. He was being used because his own files made denial impossible. Richard Caldwell directed the restructuring, Cole said. Preston presented the public story, but Richard approved the hidden transfers and ordered the records changed when investors asked questions. He also admitted that he knew the old power of attorney had been revoked and that the version presented to the bank contained altered pages. His testimony exposed his own misconduct, which was why the agreement required corroboration and left professional discipline unresolved. The jury could see that clearly.
"He is a liar!"
Richard suddenly bellowed, leaping to his feet and pointing a trembling finger at Cole.
"He drafted those documents himself. He is a parasite trying to save his own skin."
The federal judge slammed his gavel down like a thunderclap.
"Mr. Caldwell, you will sit down and remain silent immediately, or I will hold you in contempt of court and have you removed in handcuffs,"
Preston snapped. The last remaining shred of family loyalty evaporated under the crushing weight of federal sentencing guidelines.
"You forced me to do it,"
Preston screamed, turning entirely toward our father. The public defender desperately grabbed Preston's arm, but my brother violently shoved him away.
"You told me to sign the Cayman Island transfer deeds. You said the money was untraceable. You said Victor Thorne would protect us and wipe the slate clean." "Shut your mouth, you pathetic idiot,"
Richard roared back, completely losing his mind and ignoring the judge's warnings.
"I mortgaged my house for you. Your mother is sitting in a federal holding cell right now because of you. I risked everything for your worthless company." "You ruined my life,"
Preston sobbed hysterically, his voice echoing off the high, vaulted ceiling of the courtroom.
"You and Mom made me steal from Josephine. You told me she did not deserve the money."
The prosecution concluded its devastating examination an hour later. The government's case was an ironclad fortress of financial ledgers, recorded confessions, and cooperating witnesses. Richard's high-priced defense attorney stood up, his face slick with nervous sweat. He was a man completely out of options. The evidence against Richard was insurmountable. His only remaining strategy was a desperate Hail Mary to create reasonable doubt about the prosecution's primary source of information. He needed to paint me as a vindictive, sociopathic mastermind who had manipulated her own family into a state of ruin out of pure malice.
"The defense calls Beatrice Caldwell to the stand," the attorney announced.
Aunt Beatrice walked down the center aisle of the courtroom with the perfect, measured posture of a woman who completely understood the power of silence. She wore a tailored charcoal suit that mirrored my own professional aesthetic. As she passed the front row, she did not look at my father. She briefly locked eyes with me. She gave a microscopic, almost imperceptible nod. I returned it. Beatrice took the oath and sat in the witness chair. She looked down at Richard with an expression of pure, unadulterated disgust. The defense attorney approached the podium, attempting to project confidence. "Ms. Caldwell, you are Richard Caldwell's sister, correct?" "Unfortunately," Beatrice replied, her voice crisp and sharp. "And you have known your niece Josephine Caldwell her entire life," the attorney continued, ignoring her hostility. "Would you describe Josephine as a forgiving person? Or would you say she has a history of ruthless, calculating behavior toward her own family?" Beatrice leaned slightly toward the microphone. "My niece Josephine is a remarkably calculating woman," Beatrice stated clearly. "She is cold, precise, and entirely unforgiving. However," Beatrice continued, her voice slicing through the courtroom like a scalpel, "Josephine is not the villain of this story. She is merely an executioner, and she is only taking back exactly what this family stole from her." The defense attorney froze, his smile instantly vanishing. "Ms. Caldwell, I must remind you that you are here to answer my questions regarding Josephine's character." "I am answering your question," Beatrice replied, completely ignoring his panic. She turned her head and locked her eyes entirely on my father. The temperature in the room seemed to drop 10 degrees. Richard loves to play the victim. He loves to pretend that his daughter destroyed his legacy out of pure greed. But Richard does not have a legacy. "Objection!" the defense attorney shouted, waving his hands frantically. "Your Honor, the witness is completely off topic and non-responsive." "Overruled," the judge stated, leaning forward with deep interest. "The defense called this witness to establish family character. The witness will be allowed to finish her statement." Beatrice did not even blink. She kept her eyes fixed on my father, watching the absolute terror dawn on his face. He suddenly realized why she had agreed to testify. She had not come to save him. She had come to bury him. "Richard wants to talk about family loyalty," Beatrice said, her voice dropping to a dangerous carrying whisper. "But he forgot that I keep my own records. I did not come here today to smear Josephine. I came here to ensure my brother never sees the outside of a federal prison." Beatrice reached into her tailored jacket and pulled out a faded, yellowed bank ledger. She held it up high for the entire courtroom to see. "It is time to tell the truth, Richard," Beatrice announced, delivering the final fatal blow. "It is time to tell the court the absolute truth about the $12 million you stole from our grandfather 15 years ago." The courtroom fell silent when Beatrice raised the faded ledger. 15 years ago, our grandfather created a family trust, she testified. Richard controlled the records, and $12 million disappeared through shell entities and false investments. The prosecutor accepted the ledger through the bailiff, but did not pretend that an old book automatically proved a charge. He asked about custody authenticity and how Beatrice obtained it. "Josephine found the discrepancies when she was 18, Beatrice said. She copied the statements marked to transfers and mailed the originals to me because she feared her father would destroy them." Richard jumped to his feet and called her a liar. The judge ordered him to sit and warned that another outburst would remove him from the courtroom. Beatrice continued, "My discovery had changed the way my parents treated me. They began building a story that I was unstable, jealous, and incapable of understanding money. They promoted Preston as the golden child and paid professionals to create records that could discredit me if I ever exposed the missing funds." The defense objected that the testimony concerned events outside the charged period. The judge required the prosecution to connect it to a permissible purpose. The government argued that the ledger explained motive, the origin of several shell entities still used in the recent scheme, and an ongoing pattern of concealment. The judge admitted limited portions for those purposes and instructed the jury that historical misconduct was not proof of guilt by itself. Beatrice identified my handwriting in the margins and explained how she preserved the book in a safe. A forensic examiner had tested the paper ink sequence and bank account references. Several transfers matched records already admitted in the current case. The point was not that my parents hated me for being difficult. They feared me because I had recognized the structure of their fraud before I was old enough to vote. The guardianship petition was not a sudden act of concern. It was the newest version of a 15-year effort to turn the witness into the patient. The ledger changed the emotional center of the trial, but it did not allow anyone to ignore criminal procedure. The prosecutor did not ask the judge to rewrite the indictment from the bench. 15-year-old conduct raised questions about limitation periods tolling continuing concealment tax treatment and whether any of the old transactions were part of the current charged conspiracy. Outside the jury's presence, the government requested an order preserving the ledger and authorizing limited tracing of the accounts identified in it. The judge granted preservation, allowed forensic copies, and directed the parties to brief which portions could be admitted to show motive knowledge or the origin of shell entities still used in the recent fraud. He told the jury that old misconduct was not proof of guilt by itself. The defense argued that Beatrice was motivated by a family feud. The prosecutor answered with bank records. Several shell companies from the old ledger reappeared in the recent trust transfer and in payments connected to the false medical evaluations. My 18-year-old calculations matched archive statements obtained independently from financial institutions. The paper was not a dramatic relic. It was a map connecting the first theft to the newest attempt to silence me. After the evidence closed, the judge instructed the jury on each charged offense. The jurors deliberated over the trust transfer securities fraud, forged records, and conspiracy. They did not convict anyone merely because my family looked cruel. They convicted because the signatures, emails, bank trails, and witness testimony fit together without a missing link. The verdicts were read one count at a time. Preston was found guilty on the investor and wire fraud counts. Richard was found guilty on conspiracy fraud and obstruction-related counts tied to the current scheme. Patricia's separate plea remained pending in her own case. Only after the verdict did prosecutors file a detailed forfeiture notice identifying specific proceeds accounts and property interests allegedly traceable to the crimes. The court scheduled an ancillary process so innocent owners and secured creditors could assert claims. Victims submitted restitution schedules. Probation officers began pre-sentence investigations. The judge also authorized prosecutors to present any independently chargeable historical conduct to a grand jury. He did not command an indictment, and he did not announce that every Caldwell asset belonged to the government. He froze only identified assets at risk of dissipation while the forfeiture and restitution questions were litigated. Richard looked back at me while marshals prepared to escort him from the courtroom. His lips formed the words, "Help me." I stared through him. The family had not been destroyed by a magical gavel or by my wealth. They had been destroyed by the records they created, the lies they repeated, and the signatures they assumed no one would ever audit. The verdict did not end the financial work. A court-appointed receiver took control of identified business records, while banks preserved only the accounts specified in lawful process. Ordinary creditors still had to prove their claims. Investors still had to document losses. Even my own fund had to establish the priority of every note it held. Beatrice's testimony also forced me to confront something more difficult than revenge. The abuse had not begun with the current trust. It had begun when I was 18 and showed Richard that I could follow money he believed was invisible. From that day forward, every insult about my instability served a practical purpose. If the family could make others doubt my mind, they could make them doubt my math. That motive deepened the case without changing the burden of proof. The jury still had to decide the recent charges beyond a reasonable doubt. The judge said so repeatedly, and the instructions remained on the screen during deliberations. 6 weeks later, I returned for the sentencing hearings in an immaculate white suit. I sat in the reserved area for victims and authorized representatives, while reporters filled the public benches behind me. The judge had reviewed pre-sentence reports, sentencing memoranda, advisory guideline calculations, victim impact statements, financial loss schedules, and objections from every defense team. Each defendant had counsel and an opportunity to challenge the government's evidence. The sentences would not be improvised from outrage. Preston stood first. Before the judge ruled, his lawyer described the cooperation proffer, the records he helped recover, and the information he provided about Richard and Patricia. Preston asked to speak. He apologized to the investors, then tried to explain that he had spent his life obeying a father who treated fraud like strategy and a mother who treated consequences like insults. The judge acknowledged the family pressure, but refused to let it erase Preston's choices. He had stolen source code, lied about ownership, moved investor capital into gambling accounts, and signed certifications he knew were false. "Your cooperation is reflected in the sentence," the judge said. "So is the scale of the harm." Preston received 5 years in federal custody, followed by 3 years of supervised release. The judgment included restitution and forfeiture of assets traceable to the scheme. The Bureau of Prisons, not the judge, my lawyers, or Preston's imagination, would determine his facility and classification. No one promised him a comfortable camp. Patricia appeared next in her separately resolved case after entering a guilty plea to wire fraud conspiracy and offenses connected to the altered authority documents. Her lawyer argued that Richard controlled the finances and that she acted from fear for Preston. The prosecutor answered with her courthouse confession bank authentication records messages, demanding that the transfer happen before I could stop it, and evidence that she knowingly used false documents. Patricia addressed the court through tears. She called herself a mother protecting a frightened son. The judge reminded her that protecting Preston had meant attempting to strip her daughter of legal capacity and property. The court sentenced her to 3 years in federal custody, followed by supervision. It imposed restitution jointly where the law allowed, and ordered forfeiture only of identified proceeds and substitute property authorized by statute. Her placement would be decided through the federal prison system. Patricia turned toward Richard, but he did not meet her eyes. Richard's financial ruin came through coordinated proceedings rather than a single dramatic sentence declaring him bankrupt. The criminal court entered restitution and forfeiture orders tied to the recent scheme. A bankruptcy judge and trustee administered his remaining debts and non-forfeited property. The Connecticut receiver continued the estate sale. Exempt assets and legitimate third-party interests received the process required by law. The government had asked the court to treat a broad range of Caldwell property as available for recovery. The judge narrowed the order to assets supported by tracing substitute asset findings, valid liens, or the bankruptcy process. That restraint made the result harder to attack. Punishment did not replace proof. Richard's historical conduct remained under investigation, but the recent convictions guarantees civil judgments and creditor claims were enough to remove his control. For the first time in his life, he could not move money because he wanted something and assumed the family would absorb the cost. Before the marshals moved the court, addressed the money. Investors submitted sworn loss schedules rather than estimates shouted at a gala. The trust administrator documented the unauthorized $2 million transfer. The receiver identified vehicles accounts and business interests connected to the fraud. Defense counsel challenged valuations and protected property that could not lawfully be forfeited. The judge ordered a restitution plan reflecting verified losses with credits for assets later recovered through receivership or sale. He warned the defendants that restitution would survive release and that supervised release conditions would require accurate financial disclosures. Hidden accounts, nominee ownership, or new transfers could create additional violations. Preston's face collapsed when he heard that the 5-year term was only one part of the judgment. Even after prison, the debt to his victims would follow him. Patricia finally understood that a guilty plea did not preserve the socialite life she had built from borrowed status. Richard watched both of them, without offering comfort, still measuring which consequence belonged to someone else. I remained silent. My satisfaction did not come from seeing handcuffs. It came from hearing a court separate allegation from proof, trace each recoverable dollar, and refuse to let family mythology replace individual responsibility. The judge entered the final orders. Marshals secured Preston and Patricia and led them toward the side door. Richard remained under restrictive conditions while the unresolved matters continued. He was not free in any meaningful financial sense, but he was not remanded that day. Court adjourned. The reporters rushed toward the public hallway, and I waited until the corridor cleared before leaving through the quieter side passage. Behind me, Richard had no lawyer, no driver, and no account he could access without the trustee seeing the transaction. The marble hallway of the Federal Building was completely quiet, bathed in the cold fluorescent lighting of institutional justice. I walked toward the private elevator banks, my designer heels clicking rhythmically against the polished stone floor. Josephine. I stopped and turned around. Richard was standing 10 feet away, leaning heavily against the cold marble wall for physical support. His defense attorney had already abandoned him, rushing off to handle corporate clients who could actually pay their legal billing rates. My father was completely alone. He took a shaky step toward me. My security chief immediately moved to intercept, slipping a hand inside his tailored jacket, but I raised a single index finger, signaling him to stand down. I wanted to hear this. I wanted to witness the absolute, unfiltered bottom of the Caldwell patriarch. "Josephine, please," Richard begged, his voice cracking into a pathetic wheeze. He looked up at me with red-rimmed, bloodshot eyes. He was trembling violently, his hands shaking uncontrollably at his sides. "They took it all. They seized the house this morning. They froze my checking accounts. My credit cards are declining at the terminal. I do not even have the cash to pay for a cheap motel room tonight." I looked at him, my expression perfectly neutral. I assessed his deterioration with the clinical detachment of an auditor reviewing a failed business model. I felt absolutely nothing. No pity, no anger, no vindictive joy. Just the cold, sterile satisfaction of a perfectly executed financial algorithm. That is what happens when a trustee, receiver, and lawful restraint take control of a failed estate, I replied. You are no longer the person who decides where the money goes. He took another step closer, hot tears actually spilling over his wrinkled cheeks and soaking into his collar. "I am your father," he wept, his voice breaking into a pathetic, desperate whine. "I know I made mistakes. I know I was wrong, but I am an old man, Josephine. I have nothing left in this world. My wife is going to federal prison. My son is locked in a holding cell. Please, I am begging you, on my knees." He practically collapsed against the wall, clutching his chest. "Give me a chance to start over. Just a small loan. A place to stay for a few weeks until I can figure this out. You have hundreds of millions of dollars. You will not even notice a fraction of it is gone. Please, Josephine, I am a broken man. Have a little mercy." I slowly reached into my obsidian leather handbag. The sharp metallic click of the silver clasp echoed loudly in the quiet corridor. Richard's eyes widened with a desperate, pathetic flare of hope. His breathing quickened. He actually thought he had broken through my defenses. He thought the biological bond meant something to me. He thought I still possessed the fundamental weakness of family loyalty. I withdrew my hand. Between my manicured fingers, I held a single, crisp, uncirculated $100 bill. The $100 bill fluttered through the cold air, drifting side to side before landing silently on the polished marble floor, coming to rest exactly between his scuffed leather shoes. "Call a cab to go home," I stated, my voice dropping to a register of pure, freezing Arctic ice. "That is my last mercy." I turned my back on him. I did not wait to see if he humbled himself enough to pick it up. I simply did not care. I walked toward the waiting private elevator, my white suit immaculate, my empire completely secure, leaving the bankrupt ghost of Richard Caldwell to shatter completely, alone in the cold marble hallway. 3 weeks after the federal sentencing hearings, I returned to the Caldwell family estate in Connecticut for the ultimate phase of the liquidation. The morning air was crisp and biting, carrying the distinct chill of impending winter. The towering wrought iron gates, which had historically remained locked to keep the ordinary world at bay, were pinned wide open. A fleet of heavy commercial moving trucks and white commercial vans crowded the expansive cobblestone driveway. The estate was crawling with appraisers, forensic accountants, and logistics coordinators from a premier global auction house. The grand oak front doors were propped open, allowing a steady stream of workers to carry out the physical manifestations of my family's stolen wealth. Every piece of custom mahogany furniture, every imported Persian rug, every glittering crystal chandelier, and every framed oil painting now bore a stark white barcoded tag. The Caldwell legacy had been reduced to an itemized inventory list destined for the highest bidder. The scent of fresh lilies and expensive beeswax polish that used to permeate the foyer had been completely replaced by the industrial smell of cardboard boxes, packing peanuts, and heavy-duty tape. The federal court had granted Richard Caldwell a strict 2-hour window this morning to collect his exempt, non-valuable personal effects. These were items the government deemed to have zero resale value: basic clothing, cheap toiletries, and unremarkable personal paperwork. He was not permitted to take a single piece of jewelry, not a single watch, not even the expensive custom suits he had purchased using embezzled company funds. He wore faded denim jeans and a worn gray sweatshirt. In his hands, he dragged 2 heavy black plastic garbage bags. The cheap nylon stretched and strained under the weight of his remaining possessions. He hauled them across the pristine cobblestone toward a rusted, dented rental box truck idling near the service gates. The juxtaposition of the magnificent architectural backdrop and the pathetic, dragging plastic bags was a perfect visual representation of his current reality. He hoisted the first garbage bag into the back of the rental truck, his chest heaving with exertion. As he turned to grab the second bag, the cheap plastic snagged on the rough metal edge of the truck bed. The bag tore open with a loud ripping sound. A cascade of ordinary, worthless items spilled onto the cold cobblestones. Faded t-shirts, a pair of worn sneakers, a plastic comb, and a generic brand stick of deodorant scattered across the stones. Richard froze. He dropped to his hands and knees on the driveway, frantically scrambling to scoop up his cheap belongings before the federal marshals or the moving crew could witness his ultimate humiliation. His hands were shaking violently as he shoved the items back into the torn plastic. As he reached for a stray sock, he slowly lifted his head. His eyes locked onto mine across the courtyard. I did not smile. I did not frown. I did not blink. I simply looked at him with the cold, clinical detachment of a scientist observing an insect in a jar. I felt no lingering hatred. Hatred requires an ongoing emotional investment. I felt no pity. Pity requires empathy. I simply registered his physical presence as a completed task on a very long corporate ledger. He was a bankrupt liability that had been successfully erased from my balance sheet. The rusted engine sputtered and coughed before finally roaring to life. The truck lurched forward, spewing a cloud of dark exhaust fumes into the crisp morning air, and rolled slowly out of the iron gates. He did not look in the rearview mirror. He just drove away, vanishing into the ordinary traffic on the main road. I turned away from the gates and walked up the marble steps into the echoing foyer of the empty mansion. Inside the stripped mansion, counsel to the court-appointed receiver waited beside a folding table covered with inventories, appraisal reports, creditor schedules, and proposed sale orders. The professionals handling the liquidation acted for the receiver and the court, not as servants of my private revenge. "The real estate appraisal is complete," counsel said. "The mansions, surrounding land, vehicles, art, and other non-exempt property should produce roughly $38 million if the court approves the current sale plan." He turned to the distribution schedule. Taxes, preservation costs, employee claims valid, liens, and victim restitution held priority. Apex was a secured creditor through the debt portfolio acquired during Victor's restructuring, but my company could receive only the amount allowed after superior claims and court review. "Based on present estimates, Apex's net recovery may be close to $22 million, he said. "It could change if claims are allowed or the auction underperforms." That distinction mattered. I could not donate money belonging to victims, the government, or other creditors. I could decide only what to do with the distribution legally payable to my company after the receiver completed the process. Counsel placed a draft assignment on the table. Under the standard option, the future distribution would enter Apex's general holding account and become another number in a portfolio already worth hundreds of millions. I looked around the empty dining room. The long table where Richard once dictated family loyalty was gone. Barcoded tags hung from the remaining fixtures. Every room had been converted from a symbol of power into an inventory line. "Prepare a board consent and restricted grant agreement," I said. "After the court approves the final distribution and every superior claim is paid, Apex will donate its entire net recovery to the Vanguard Coalition." Counsel recognized the organization a national legal defense fund supporting women facing financial abuse, forged signatures, hidden assets, and coercive control. "I want the grant to fund emergency forensic accounting, independent counsel, temporary housing, and asset preservation litigation," I continued. "No press release, no plaque, no use of my name in fundraising. The receiver must certify the final amount before a dollar moves." He warned that the board had to document the business and charitable rationale review tax treatment and confirm that no pending creditor objection would be prejudiced. "Do it correctly," I said. "I am not interested in a symbolic transfer that creates another lawsuit." Before the board vote, I required a conflicts review. Apex had purchased the secured debt as an investment, and the charitable transfer could not be disguised self-dealing or a mechanism to avoid obligations. Independent directors reviewed the proposal, confirmed that the firm remained solvent after the donation, and recorded why the grant advanced Apex's long-term mission of identifying and preventing financial abuse. The receiver's counsel also reminded me that auction results were uncertain. Some paintings might sell below estimate. Environmental work could reduce the land value. Litigation over a third-party lien might delay distribution for months. I accepted every condition. The point was not to announce a perfect number. The point was to relinquish whatever amount the court ultimately determined belonged to Apex. The drafting took more than 10 theatrical minutes. Counsel revised the priority clauses, added a condition requiring final court approval, and prohibited the coalition from using the grant for personal benefits or political campaigning. My board, joined by Secure Conference, reviewed the resolution and voted. Only then did I sign. The signature did not instantly dissolve the mansion or bypass the receiver. The sale still required notice bidding, a closing final accounting, and a distribution order. But the portion that eventually reached Apex would be transformed from family wealth into a permanent tool against the kind of financial coercion my parents had tried to use on me. I walked through the foyer one last time. Richard had already driven away in a battered rental truck with 2 torn plastic bags. The federal marshals remained at the gates, while auction crews loaded the final tagged items. I felt no need to celebrate his humiliation. Hatred would have kept him on my books. The cleaner result was indifference. Outside, my security chief opened the town car door. I entered, connected my tablet to the corporate network, and reviewed the next quarter's acquisition targets. The estate continued through its lawful liquidation. My attention had already moved on. As workers removed the last chandelier, I remembered Patricia polishing it before charity dinners and Richard pointing to it whenever he lectured me about gratitude. It had never represented family stability. It represented debt performance and money taken from people who trusted them. At auction, it would become simply another asset with a lot number. I walked out of the empty dining room, my heels clicking sharply against the bare hardwood floors. I stepped out through the grand front doors, descended the marble staircase, and walked across the cobblestones toward my waiting car. I did not pause to look back at the estate. I did not glance at the moving trucks or the auction banners. My security chief opened the heavy armored door of the town car, and I slid into the luxurious leather interior. 18 months later, those acquisition targets had been absorbed into a new holding company, Apex Pinnacle Holdings. I stood in a glass office occupying the top floor of a Wall Street tower, looking across Manhattan and the Hudson River. The height did not make the city small. It made the distance between my old life and my present one measurable. The office was severe, without being empty black stone, brushed steel, clean lines, and no family photographs. Nothing displayed the Caldwell crest. The only name on the reception wall belonged to the company I had built without their permission. Richard lived under the restrictions created by bankruptcy receivership and the unresolved consequences of his conduct. Patricia was serving her 3-year sentence. Preston was serving 5 years and remained responsible for restitution after release. Their outcomes were not trophies arranged for my enjoyment. They were closed files. The Vanguard Coalition had received the final net distribution approved by the Connecticut court. Its lawyers and forensic accountants were using the grant to preserve assets, challenge forged documents, and help women obtain independent representation before abusers could empty shared accounts. I never attached my name to the program. My intercom chimed. Ms. Caldwell, both legal teams have completed their review. The board is ready and the merger documents are on the way. Bring them in. My executive assistant entered with a thick leather portfolio. Behind her came my lead counsel and representatives of the company we were acquiring. The transaction was valued at $65 billion. It was a hostile approach that had become a negotiated strategic merger after months of regulatory review, lender diligence, employee consultations, and negotiations over governance. The deal expanded our international reach, but it did not create an illegal monopoly. Antitrust approvals required divestitures, information barriers, and limits on several overlapping business lines. The opposing lawyers looked exhausted. Their executives had attempted poison pill defenses, golden parachutes, and last-minute financing conditions. My teams answered with audited numbers, enforceable commitments, and a price their board could defend to shareholders. Everything reflects the approved terms, my counsel said. Apex receives controlling voting rights subject to the regulatory conditions. The board transition follows the agreed schedule. Employee obligations, pensions, and existing client contracts remain protected. The first closing payment stays in escrow until every condition is certified. I opened the portfolio and reviewed the signature pages. For most of my life, my family had described precision as coldness and independence as illness. Now those qualities protected investors, employees, and counterparties from hidden liabilities. Power was not the ability to ignore rules. It was the ability to understand them better than the people trying to use them against you. My assistant placed the silver fountain pen beside my hand. I signed the merger agreement. I signed the financing authorizations, governance certificates, and regulatory undertakings. Every signature moved capital through supervised accounts and transferred authority under documents reviewed by both sides. The acquisition is complete when counsel confirms the final conditions, I said. Release the initial payment from escrow only after certification. Begin the approved board transition. Preserve payroll benefits and all records, subject to the integration hold. The lawyers gathered their copies and left. My assistant remained long enough to ask whether I wanted espresso. Black, no sugar. The machine ground the beans with a low mechanical sound. She placed the small porcelain cup on my desk and left to execute the closing instructions. I carried the espresso to the window. Financial networks would spend weeks calling me ruthless, calculating, and terrifyingly ambitious. They would not be entirely wrong. I had built a career from entering rooms where powerful people believed complexity would protect them and showing exactly where the liabilities were hidden. But there was a difference between cruelty and discipline. Cruelty uses power to trap people who cannot defend themselves. Discipline builds systems that make the trap visible before it closes. I did not miss the family structure that had tried to erase me. I did not secretly wish Richard would apologize correctly or that Patricia would finally choose me over Preston. Their validation had no remaining value. I was 33 when they tried to place my life under their control. Now I stood at the center of an empire governed by my signature, my judgment, and boundaries no relative could cross. I was not the daughter they had failed to break. I was the woman who had stopped allowing them to define the terms. The empire was secure. The enemies were no longer active liabilities. They were footnotes in an audited history, and the next era had already begun. The merger had taken nearly a year of work. My analysts had tested revenue, quality, cybersecurity exposure, pension funding, litigation reserves, and the ownership of every critical patent. The opposing board had rejected our first offer, adopted defenses, and invited rival bidders. I did not manufacture a crisis or plant false information. I waited until market pressure and verified liabilities made negotiation more rational than resistance. That patience was the clearest measure of how far I had come. My parents had always confused power with immediate obedience. Victor confused it with intimidation. Preston confused it with applause. I understood that durable control came from preparation, enforceable rights, and the willingness to walk away when terms were bad. On a side table rested no trophies from the Caldwell estate. I had kept neither the Cartier clock from the foyer, nor the silver service Patricia displayed at holidays. The only object from that period was the black leather folder from the first guardianship hearing. It remained closed inside a locked drawer, not as a shrine to pain, but as a reminder that documentation had once protected my legal existence. The assistant returned briefly with confirmation that escrow had received the closing certificate. I authorized the release through dual controls, requiring counsel and the chief financial officer to approve the wire independently. Even at the peak of my authority, no single person could move $10 billion because of a dramatic command. Systems existed to restrain everyone, including me. When the confirmation arrived, I allowed myself one quiet breath. There was no ballroom, no crowd, and no relative waiting to be humiliated. The deal was complete because thousands of details had been made true. The silence around that truth felt permanent. Nothing could reverse it. I looked down at the sprawling metropolis below. The media would undoubtedly spend the next month dissecting the Genesis acquisition. Financial networks would label me a ruthless corporate titan. They would call me cold, calculating, and terrifyingly ambitious. They would write extensive profiles on the billionaire woman who operated without a safety net, without a family, and without a shred of remorse. They would be entirely correct. I took another sip of the espresso, watching the sun reflect off the glass facades of the neighboring skyscrapers. I had achieved the ultimate American dream, stripping it of its sentimental illusions and refining it into pure, unadulterated power. I was an entirely self-made sovereign. I had survived the psychological warfare, the financial betrayal, and the gaslighting of my own bloodline. I had taken the bricks they threw at me and used them to build an impenetrable fortress. There was no longing for a traditional family dynamic. There was no secret sorrow hiding behind my success. I felt completely whole, entirely autonomous, and profoundly dangerous. I had stepped out of the shadow of the Caldwell family and into a blinding, brilliant light of my own creation. I was the executioner of my past and the absolute master of my future. The empire was secure, the enemies were liquidated, and my reign had only just begun. The most profound lesson to be extracted from Josephine Caldwell's ruthless ascent is that true liberation requires both absolute financial independence and the clinical detachment to sever toxic ties, even those bound by blood. Society often conditions women to be the perpetual peacekeepers, expected to absorb familial abuse under the guise of duty, loyalty, and tradition. Josephine's journey completely shatters this illusion, proving that real power lies in seizing the pen and rewriting the narrative on your exact terms. When betrayed by the very people who were supposed to protect her, she did not dissolve into self-pity or seek their hollow validation. Instead, she weaponized her intellect and her trauma, transforming her vulnerability into an impenetrable corporate fortress. The ultimate revenge is never about chaotic emotional displays or screaming matches. It is about pristine, calculated execution. It is the quiet, devastating realization that your abusers have become entirely irrelevant to your future. Josephine teaches us that we are the sole architects of our destinies, and sometimes clearing the foundation requires letting the old, rotten structures burn entirely to the ground. If you are holding on to relationships that drain your worth, find the courage to liquidate those liabilities and start building your own empire today.